Evictions can be scary. They're worse when you lose. We're talking all about why landlords lose their evictions in eviction court. Let's get started. Thousands of evictions are filed every workday in this country, but not all of them come to a successful conclusion. A lot of times it's because the landlord simply wasn't ready to present a winning case to the court. Today I want to talk about the 9 reasons your case might be a big fat loser. For the uninitiated, sometimes it's as simple as not making the ask. If your eviction fails to have a proper demand for possession, there's no way you're going to win your eviction. The truth is, to begin an eviction, you have to make some kind of written demand for possession. The fact that you've told your tenant time and time again to do this or not do that just isn't enough. All over the country, you are required to give a written notice to your tenant having to do with eviction. And if you give a notice that doesn't actually demand possession, you're probably not in a good position to stand in front of the court and ask for a judgment for eviction. Make sure that your notice to the tenant, number 1, is in writing, and number 2, actually makes a demand. It's not complicated. In Texas, for example, I tell landlords all the time that their notice for possession should be an unequivocal demand. 2 words, very simple: get out. If you're not telling the tenant that they need to leave, you're not making a demand for possession, and your eviction is likely to fail because of that. Okay, so let's say you did send a notice in writing, but you sent the wrong kind of notice. If you don't understand that there are differences between a notice of non-renewal, a notice of default, a notice of termination, a notice to vacate, then you may be sending the wrong document at the wrong time for the wrong reason. And when you want to evict someone, if you're sending an improper notice, you're shooting yourself in the foot, because the court is likely going to require you to demonstrate that you issued the right kind of notice. If you can't do that, you just can't win. But if it comes down to the fact that you don't know the difference, then you're probably not ready to be a landlord yet. Make sure you have all the learning you need to know what notice to give, when to give it, and why that's important. When it comes to an eviction, you got to give the right notice or you don't get your eviction. Here's one that gets landlords all the time. Your notice didn't give enough days to the tenant in accordance with your local laws. Now, I'm not going to get too far into this because different jurisdictions are going to have different requirements. But if you're supposed to give a 3-day notice and you only gave 2.5, guess what? That doesn't math. And because it doesn't math, you're not going to get your eviction. Understand what the rules of your jurisdiction require. Understand what your lease requires, and make sure that you are giving notice that your court will accept as sufficient. If you're unsure, then it means you're either A, not super knowledgeable about what's in your own written lease, or B, not super knowledgeable about what your state or local jurisdiction require for you to have an effective eviction petition. But before you ever file, you need to become sure, or put the eviction in the hands of someone who is sure, because you're not ready to do this on your own. This next one is a bit of a ticky-tack one that some courts see as absolutely indispensable, but perhaps your notice simply didn't indicate what the tenant got wrong. If you didn't mention the fact that they're being evicted for some non-rent violation, a rent-paying tenant is going to show up to the court and say, Your Honor, I don't even know why we're here. I pay my rent on time every time. And then the court might ask you, why are we here? Because your notice doesn't indicate that there is a default. It just says get out. And so it comes down to whether or not that's fair. To remove this possibility, make sure that your notice indicates clearly what the tenant did wrong. If it's non-payment, tell them you didn't pay the rent. If it has to do with some non-rent lease violation, make sure you indicate that. In fact, we encourage landlords not just to indicate what went wrong, but to also indicate where in the lease that particular thing to do or thing not to do is stated. If you adequately inform your tenant of the thing they did wrong, number 1, they might actually fix it. But number 2, if they don't, and they had plenty of time to do it, you can demonstrate this to the court as a valid basis for possession. But if you didn't do that, don't be shocked when your judge says no eviction for you. Another technical problem that landlords create for themselves is that they don't deliver the notice to vacate properly. In Texas, where I practice, there are very specific rules outlined in Chapter 24 of the Texas Property Code, rules that landlords get flat wrong all the time. And if you're not following the rules of your jurisdiction, you're likely to get your eviction tossed out for bad delivery. Even if, get this, even if your tenant actually got the notice, if the method you used to deliver it was not proper, your judge could say, nope, you didn't follow the rules, so I'm not signing this eviction judgment. Make sure that you know how to deliver your notice, because it doesn't help you that you've got a perfectly drafted notice if you don't know how to deliver it properly. You only have so many feet. Stop shooting yourself in them by filing in the wrong court. If you're unsure where to file an eviction, call the court and ask first. Make sure that if it's a matter of a particular court within your county, then you call that court first before you go and just file something that doesn't belong in that court. In Texas, for example, counties are broken up into usually multiple precincts. And so you're going to want to know what precinct your rental property is located in. Additionally, you're going to want to know, is this filed based on where the property is located or where I'm located? Generally speaking, it's where the property is located. So make sure you understand where your jurisdiction requires your eviction to be filed, because the last thing you need is to show up and for the judge to say, sorry, there's no way I can issue this eviction. Your property is not within my jurisdictional boundary. So good luck filing it properly, but you just wasted a lot of time and money filing it in the wrong court. One technical problem that landlords get wrong all the time has to do with the parties featured in the eviction petition itself. Sometimes landlords get this so wrong because they're just not paying attention to what's documented in the lease. If you go by multiple names as a business, for example, and you use a name that you sometimes use in your lease and sometimes you don't, well, that's the cause of a lot of headaches and could be the cause of your eviction petition being rejected by the court. If you use the wrong name and that's not the name that's featured in the lease, the court could kick the case out on a standing issue. You might, for example, use a business name in the lease and try to file the matter in your personal name, and that generally doesn't work. Additionally, you might mess up by not including the proper names of the defendants. You might, for example, as is the case in Texas, fail to list all of the necessary defendants. In Texas, you're required to sue to evict everyone who signed the lease and continues to remain in possession, which means if 3 people signed and all 3 are still in possession, you can't just sue the main one. You have to sue them all. Otherwise, the court doesn't have the authority in the state of Texas to issue that judgment. And that's true in a lot of states. So make sure if your jurisdiction requires all of the named tenants who remain in possession to be featured in your eviction, that you list them all, you sue them all, so that you can actually win your judgment. If you fail to do that when it's required, you're going to lose. While generally speaking, it is possible to evict a tenant, even a tenant who pays the rent, for a non-rent violation, sometimes landlords go for something that's so weak or that's so easily cured that a court is just not going to grant it. If, for example, you have a tenant who failed to cut the grass and you issued a notice to vacate because they failed to cut the grass, they went a whole 10 days without cutting the grass when they're supposed to cut it every week. Well, what happens if you file and then they cut the grass and they cut it every 7 days thereafter and show up to court with a live stream of that beautiful, beautiful yard, showing it immaculately mowed, everything looking perfect? How's the judge supposed to respond to that? You know, in a lot of senses, if what you have is a repeated instance of your tenant not doing this and multiple notices of default issued to that tenant, you've got a stronger case. But if you've just got one weak instance of a small thing that has already been cured, it's unlikely that the court is going to grant your eviction because A, the problem doesn't exist anymore, and B, the court might see it as insufficient. They might, for example, argue that the tenant has substantially performed within the regulations and the expectations of the lease, and that you're not entitled to possession because of that. Make sure that you have a strong cause of action, generally speaking, even if it's been cured, one that's been issued by multiple notices of default, where you can demonstrate to the court, yeah, maybe they took care of it this time, but look what it took me to get there, Your Honor. I've had to issue notice after notice after notice, and they still won't do it unless I go to extreme measures, which is why I'm seeking this eviction. But if you just can't demonstrate to the court that you have a strong enough basis, particularly when it comes to non-rent violations, you're probably setting yourself up for failure. This last reason that landlords lose their evictions has to do with evidence. You can't evict somebody on a hunch. You have to be able to prove the thing. Sometimes I have landlords who come to me and say, well, I'd like to evict my tenant because I believe they are conducting illegal activities on the premises. They'll say something like, there's a lot of cars that come by and people suspect I've got a drug dealer on the premises. But you have no evidence, no police report, no eyewitness testimony, no photograph or video evidence. You've got nothing but your gut. I'm telling you, that's not going to be enough. Your suspicion of criminal activity doesn't constitute valid evidence of criminal activity, and you're not going to be successful. Well, let's say you do have eyewitness testimony of an actual crime being committed, but you didn't bring that witness with you to court. You can't, as a matter of hearsay, generally talk about what somebody else has seen as evidence in your eviction trial. The court is unlikely to grant you any eviction on that basis. Finally, it could come down to a matter of the evidence presented by the defendant being stronger than your evidence. I've seen landlords sometimes show up with nothing in their hands, be turned away by a court when the defendant has shown up with record after record after record, whether it has to do with rent or some other non-rent violation. If the tenant shows up with more and better evidence than you, you can't expect to overcome that. Don't show up to court empty-handed, and make sure that if you present a case to the court that you've got a provable, valid basis for your eviction. Otherwise, you're likely to be turned away. No eviction for you. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients during the month of October, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course. Presenting a winning case for eviction in an eviction court can be complicated. You need all the resources that can be made available to you in your hands before you ever begin that process. So much of a valid eviction comes before that filing, but you also need to be prepared for what's expected of you on the day of trial. For more information that has to do with filing great evictions and submitting superb notice, make sure that you check out all the rest of the content that's on this channel. YouTube seems to think that this video right here is the next best thing for you to watch. But until next time, landlords, happy leasing.